There we go. All right, can somebody else sound off again? Because we had our volume down on the TV in here.
Hello.
There we go.
There we go.
All right, thank you, Tanya.
Good morning. My name is Carol McKenna. I am or was a real estate title and settlement agent for many years, and nobody can know how old I am anymore. So,
It's her birthday tomorrow.
so today we're talking about chain of title and airship owner view, airship as far as title goes, and we have a couple of files where the property passed from the original owner who died, and that was Neil and Agnes Fairley. And Agnes died, Neil was left. And where are the documents? Okay, so I'm on the wrong. Okay, hang on.
I told her to look at it.
I'm on the wrong page. I'm going down. I'm not going back.
Oh,
I need to go back.
you need to go back.
I need to go back.
Okay,
Take me back.
here we go.
Stay here.
Where would you like to go?
Well, down.
Oh,
We did this. Okay, wait.
what are you looking for?
The deed. The deed to Agnes and Neil.
Up.
Agnes and Neil and
That's Agnes and Neil.
yeah, but that's not the deed.
Okay,
Not the deed.
I don't think you sent that to me.
Uh-oh. Well, okay.
Okay, hold please. Yep. See if I got that. Yeah, it's not here. I don't have an Agnes and Neil. Sorry,
Okay.
but I have this fun one. There we go. That's what I got. Or I can, hang on, see if it will make it more better. I think we're having technical difficulties.
I know I am. That's
Is that it?
yep.
Okay.
That's it.
I just didn't like the way that I did this.
Okay.
It didn't do it the way that I was supposed to do it. Okay. Sorry. Our slideshow didn't come together. Wait, right. There we go. All right, there we go. There's Agnes and Neil. If everyone can see this. There you go.
Okay, so this first sheet is simply what the abstractor sends in. Okay, moving on, I guess.
I hope sure.
Okay, so Agnes and Neil owned this property since 1963. Make my thing better. I can see it, 83. Okay, if you look, you can see at towards the bottom of the page the derivation clause. or also called the it being clause. The it being clause tells you where the property came from. So it was conveyed to the party of the first part by a deed from Darrell Miller, sole acting trustee, to the Fairleys. Okay, that's pretty easy. Tell me to click anywhere, Christine. Never mind.
I'll go back to slideshow. You want to back to slideshow or?
So here's the problem. Agnes Fairley died. What happens to the property? Well, what happens to the property? Agnes and Neil were husband and wife, tenants by the entirety with the right of survivorship as a common law. What that means is that one of them dies, the other one gets the property. Good job, Melody. Okay, so
Which page? Next.
then Neil died and left as his sole heir Agnes.
But I thought Agnes was dead.
So did I. Let's see. Agnes died
2006.
2006, so she must have been, yeah, she was the sole. Okay, I got it wrong. Neil died first, then Agnes. So Agnes got the property because of Neil's death. She was the only owner of the property at the time. So her heirs were Neil A. Farley Jr. and John W. Knight. Pretty simple. They were both her sons. And this was a pretty simple conveyance. However, when you have a list of heirs, can you rely on that to be correct? You know, it's recorded in the land records, and you would think that, yeah, you can rely on that because it's recorded in the land records, right? No, you can't. In any event, what we required was an obituary, which also,
Have to be in the middle of the page.
oh, also lists who he was survived by. So it says he was preceded in death by his mother and father. He's survived by his two sons, Derek and Darren, and a devoted brother, John W. Knight. Did that match the deed of heirs? I mean, the list of heirs? Mm-mm. Mm-mm. It did not. So that's a problem, okay? Because John Knight and the two boys had an interest in the property. Okay, so what do you do about that? There was a court battle in which John Knight filed suit, and the property was awarded to him and the two boys. So, easy enough, property closed, everything was fine. However, we get to the file where Clarence Herring died, and he left 6 or 7 heirs.
Who's Clarence Herring?
Took my glasses off, I don't know. That was Clarence Herring. There he is. That's him right there.
How does he come in to this?
This is the next file.
Oh,
So Clarence Herring died and left supposedly 8 heirs. And again, you have to have the documentation showing A, that he died, and B, that his heirs are correct and listed in the land records. Because if you rely on the list of heirs only, then you don't have proof that all the heirs are listed.
That's what you gave me for planetarium.
It really isn't.
It really is.
So
Hang on.
again, Clarence Herring died.
You can move it with one finger and you have to just hold it with two.
I have no idea what this thing does. Anyway, the list of heirs lists several more people than are listed on the list of heirs. I'm sorry, his obituary lists several more people than is listed on the original list of heirs. So they went out and they found more heirs. And they filed a revised list of heirs, adding 3 additional people. Okay, so all of those people have to be accounted for. Anyone within that list, and there were many, who died, their heirs had to be located. We had needed their obituaries and death certificates if they died, and some did. Um, and it passes down. So if say Clarence Herring had 9 heirs, then each of the heirs got a 1/9 interest in the property. If the original person heir dies and it passes to their children, the children have a 1/18 interest in the property, and so on and so forth down through the generations. And there were a few of them. So this was very difficult because there were so many heirs and so many of the heirs had died. I went back and forth and back and forth and back and forth with the selling, no, the listing agent. Buyer side does not clear title. Seller side must clear title. Okay. Well, the seller side didn't know how. So I did step in and I got everything together. And then they found one more heir. And this took days. This took weeks to find all of these people, whether they were dead or alive, whether they had been married, divorced. You have to have, property in this day and age passes from husband to wife. If the wife is deceased, it passes to the children. If the children are deceased, it goes to, I'm sorry, their heirs. So they need to provide us with death certificates and obituaries. The death certificate is important to verify that somebody like James Herring, who that's a common name, we have to make sure that it's the right James Herring. So we have to go through all of this mess in order to get to the end result. And the end result was not good. The end result is that Jamal Bowles could not be found. He just could not be found. He was nowhere to be found. At this point, the listing agent is yelling at the selling agent about, how it is my responsibility to clear title. And my selling agent is going, hello, no, seller has to clear title. Okay, fine.
Yeah.
Um, but they couldn't. And neither could I. I couldn't find Jamal Bowles anywhere. So what happens then? What happens when you have a party in interest that cannot be found?
Go to court.
Go to court. You go to court and you file what's called either a partition suit or a quiet title action. Well, these people did not do that. There were too many of them, too many arguments, too many hands in the pot. It wasn't worth it. So the
Yeah.
property sits to this day
Unsold.
unsold because of that one error. And when I threw up my hands and said, I have to step back, the listing agent was incensed. Um, I can't pretend that I know something that I don't. So in any event, that's Christine, I want deeds.
I'm coming. Coming, mother. Which deed would you like?
I want the thing called deeds
Oh,
right there.
sure thing. There you go. View on.
Okay, so I put together the deeds. The first deed that's shown here is the deed to Clarence Herring.
I would also like to mention that with all the hands in the pot on that one, that everyone got yelled at because the listing side couldn't provide clear title. The house was an investor special for $50,000. Everyone wanted their $10.
And you know what happens when it doesn't close? Nobody gets paid.
Yeah, I
So
mean,
I spent weeks on this thing and got
not a
nothing out
one
of
of
it.
us got paid, but and also is sometimes when there is a bejesus amount of errors, when you can find them, the best option is for some of the other heirs that are getting more money than the $100. It's easier for them to buy the others out so that there can be one signer.
And that is what some of your investors are doing. Right. So in any event. Okay, so derivation of title, okay, goes back. If you have a general warranty deed, the chain of title goes back to England, to the original land grants, and you can find those things in the land records if you want to take the time to do it.
Unless you get on the other side of the Mississippi.
Exactly. But for Virginia, we're talking about Virginia
We
only.
are talking about Virginia. However, once you cross the Mississippi River, they do not go back to England.
No, some of them go back to France.
Some of them, yeah, go to Louisiana, they go back to France.
Mhm. Okay, so the derivation of title, again, it's the it being clause. Um, you know, property conveyed to somebody by somebody. That shows you where to go to find the next deed in the chain of title. And what you're checking for is you're checking to make sure that it's the same property, it's the same subdivision, and that it follows person by person. So James Nixon conveyed the property to Clarence Herring. It says there that he's a widower. Okay. And this next deed shows where Mr. Nixon got the property. His wife was not mentioned. He did not take it as husband and wife tenants by the entirety or with anyone else. And so you look again at this and you see that it's the same lots that were conveyed originally with the prior deed or the next deed. And Mr. Milburn conveyed it to Mr. Brinkley, who is the grantor on this deed. And then we move along. This one has a deed of trust. They assumed a deed of trust here. And again, you have to research that and make sure that that has gone away. And then it's just, more of the same. Brinkley conveyed it to Milburn. Everything is good so far. The problem arose because there were so many heirs and so many heirs died. And then the one heir could not be found. And I find all this stuff very, very interesting, which I'm sure you guys probably don't.
I think, yeah.
Um,
Property can
Yes.
never be sold.
What are we looking for?
Sit there and
Well, there are
What would you
a
like?
lawsuit has to be filed to quiet title. I want the slideshow.
The whole slideshow?
I don't know.
It's missing things. What do you want?
Um, no, I don't. That's I just want the slideshow now. So the option is to file suit. Um, all of the heirs, including the unknown heir or the missing heir. I mean, I've seen suits filed because the heir,
If you have a will with the heirs listed, is that what you call this clean slate for this?
it's cleaner, but again, if any of the heirs that
Here,
are beneficiaries under the will die, you're in the same boat.
I don't know. That's the beginning. Not gonna show the whole documents.
Like, so
Gonna
like
show a portion of
the,
them.
so like the state was like wanted to like build something over it. Like, do they still need to file a suit to
Yes.
all theirs? Okay.
Also, if
Or they could take it by eminent domain, which is also basically filing suit.
you can buy a portion of the property. In other words, Jamal Bowles couldn't be found, but all the other heirs could. And we ended up with 12 living heirs, including Jamal. You could actually buy 11/12 of the interest in the property. And then, well, I'm sorry, you would buy the entire property, but then you would only have the 11 heirs sign the deed. The remainder, Jamal's portion, would be escheated to the state, which means it gets paid into that, where you can look up online and you can type your name in and you can see, hey, I'm owed money. Yeah, that's how that works. That goes into the state's coffers and lives there probably forever because Jamal probably is no longer with us, since he can't be.
And nobody claimed him.
Yeah, nobody claimed him. So, and
There was a lot of them. There was just a lot of kids. I mean, that man had a basketball team.
are we talking about Clarence?
Yeah,
Yeah, I think he had 9 heirs,
he had like 9 kids of his own,
and then they all had kids
and
of
then
their
they all
own.
had kids, and so some of these kids were kids of the heirs that were deceased, and like there was, and one of those had 5
And
or
the thing is
6.
that they were ignoring the wives. Some of these people were married that had all these kids were married, and none of the wives were accounted for. If Joe died and he was married to Mary, Mary would inherit his entire interest, not the kids. The kids would still have no interest until Mary dies.
Right.
So it's a fun ball of wax, and I really enjoy doing this kind of stuff. Um, thank you. In any event, we ended up with, I think it was 12 heirs,
I
and
think we started out with
third,
26 or 32 before we eliminated,
yes,
whittled the list down to the 12.
and they were all alive and well, and we could have had a closing if only Jamal could be found. So, and again, it's quiet title action or it's a partition suit. Partition suit escheats the funds for
And
Jamal
we told
to
the
the
listing
state.
side what had to be done, and they didn't want to do it.
They did not.
And the listing agent wanted to scream and cry about it and say how it was our fault and that we had to provide clear title.
They came and they said, well, Jamal Bowles is an heir. Okay. I add him to the list of things that I need to do. And then they came back and said, oh, no, he's not an heir. Okay. Give me some proof of who this guy is and what his relationship is to somebody else in this chain of nonsense. I had spreadsheets like, wall wide, trying to show all of the relationships between all of these 32 people and their percentage interest. Because, you have to disperse to each heir and you have to know how much money each of those heirs is entitled to based upon their relationship to the original heirs. And yet when you get a file like this and you figure out that you've got a problem like this, walk away.
Oh, it's doable.
It is doable.
Don't be dramatic.
I mean, we made it all the way to the very end, and
Yeah, had they actually filed the lawsuit, it would have been able to close.
yep, it would have been.
They just refused to do it. Had they started paying off people their $50, because again, this was a $50,000 piece of property. Had they just started paying off heirs and being like, here's your dollar, we could have ended up with just one or two people signing instead of at all heirs. And these people were a little extra, I'm gonna say, because they wanted it mailed between them so that they could all wet sign the same contract.
Mhm.
None of them would electronically sign it. They all wanted it mailed between them in different states and different places so that they could wet sign it. It was, I think I still have it. I think I have one copy of it where there's like 27 signatures at the bottom of it, all in pen.
Mhm.
And I was like,
Well, we've had more than one of these types of files. We had one where there was a woman living in a house. She had three sisters. Um, and she was taking care of the property. She was paying the taxes and doing all that was necessary to maintain the property. And she wanted to sell it. So, well, she inherited it along with her three sisters. So there are four interests in the property. Her sisters were everywhere and anywhere. They all had children. A couple of them died. One of them was in a nursing home and incapable of signing anything. So, we figured it out. We had 15 people that needed to be paid, including this woman that lived in the house for all these years. Well, unfortunately, the woman that lived in the house all those years thought that because she had taken care of the house and paid all the taxes and, incurred all the expenses, that she should get all the money. And it doesn't work that way.
no.
It doesn't work that way. Had another issue where there was a young man who was an heir to a property along with his aunts and uncles. And he didn't want anything to do with it because one of his aunts had raised him and he wanted all the money to go to his aunts and uncles who had been beneficial to him. And that was fine, except that they never added him to the list of heirs because he wasn't going to get an interest. You can't do that. You have to list all of the heirs and you have to make sure that all of the heirs are accounted for. Otherwise, there can be what? A claim on title.
Yeah.
Title company has to get involved and figure out what to do. And that's, of course, provided that you bought title insurance. If you did not buy title insurance, good luck. Yes, you will have to have a lawsuit filed and to address the missing issue. So this young man signed a affidavit of disclaimer of interest. Okay, that's great. It said the right things. Now, there was another one where there were affidavits of disinterest signed. However, when you disclaim your interest in the property, you must do so for your heirs. Okay, because otherwise, it doesn't matter that you disclaimed your interest. Your heirs still have an interest in the property. So that is how that works. Now, title company that I worked with, one of them said, no, we rely on the list of heirs. Well, I hope I just showed you that you can't rely on the list of heirs because many times it is incorrect. Many times somebody decides that this person should not have an interest in the property, therefore they're not an heir and they're not going to be put on the list of heirs. Again, that's not the way it works. Had another file where man's wife died. He had two sons. He remarried, second wife. She had two sons. The boys, when father dies, his two sons go down and file a list of heirs, naming themselves as heirs. Well, under Virginia law, the wife gets a 1/3 interest. The second wife gets a 1/3 interest in the property. The children get the other 2/3. So the wife goes down and files a list of heirs of her own, saying, I'm an heir, and those two boys are heirs. Well,
Her own children, right?
no,
No,
No.
just those two.
yeah, those two, the fathers,
Yeah.
yeah, the husbands. Anyway, the abstractor who did the title search, this was a foreclosure property, missed the second list of heirs. Okay, so the foreclosing attorneys were relying on the list of heirs filed by the two boys. And the abstractor missed the fact that the wife had an interest in the property. So what happened?
Your boys got everything?
Title claim was filed.
Oh.
Title claim was filed because the two boys went out immediately and put a deed of trust on the property. So they put a mortgage on the property and they were the only ones who signed. So the lender was only entitled to a 2/3 secured interest in the property.
And wife got paid.
Not under that scenario.
No, but she got paid when she made that title claim.
She did not make the title claim. The lender made the title claim. So
She could have went and made a claim.
she didn't have a title policy.
No, but she can still claim the property. She
could have filed a lawsuit.
She could.
Yes.
The
Yes.
title paid her to go away.
So, well, title claim comes and the title claim goes forward. The wife, in the meantime, has died and her two boys have inherited her interest. Okay. So then what? So the two boys have an interest in the property. The title company says, well, we can settle this by what?
Paying her to go away.
Yeah, they pay out the boys' interest. And it turns out the boys had judgments against them. So they issued a letter of indemnity over the judgments. And this one was kind of fun because I was not really involved until Michael Glasser came to me and said, hey, I think there's something wrong here. Can you review this? So I reviewed it and I said, no, it was handled just fine. And he said, well, no, they're telling me that, it wasn't done properly. And so Glasser went ahead and foreclosed on 2/3 of the property. When the other third of the property was bought, the bank owned it. It was conveyed to the bank. So they owned the whole property and it was sold. So he's getting calls from this underwriter. And she is saying that no, this is wrong. They can't do it this way. And I said, no, it's correct. And we went back and forth and back and forth and back and forth. And it ended with Michael calling me to his desk 3 times, telling me, I told him the scenario and all the steps that were taken and said, this is correct. And the woman would call back and say, no, this is incorrect. I said, okay, Michael, let me print you out some documents. Okay, we get the documents and no, I'm still right. Yeah, I'm still right. So we go back and she calls again and says, no, I've reviewed it. It's wrong. And I was called into Michael's office once again. And he said, well, Carol, I think you're wrong. And I said, Michael, I am not wrong. And I went and called the woman and spoke with her myself. And I had to go into infinite detail to make her understand that the timeline was correct, that the way that things happened, the way that the title claim was handled was correct. And finally got that one off my desk. But there are many times where there are conflicts between what one underwriter thinks and what another underwriter thinks. And those conflicts are many times the death of a file. My philosophy is close it. I do what I can to take it to closing. I don't mess around with arguments over things that don't make any sense. I had an argument with an attorney who told me that a power of attorney that a corporate client was using was invalid because it said it was organized under the laws of the United States of America, and the company was organized under the laws of the state of Colorado, which is in the United States. So I said, hey, Colorado's in the United States. Should be able to use this power of attorney, right? I think I almost drove him to a heart attack. He was so mad at me. And I said, look, if you can't close it, can you offload the file to someone who can? Because we really don't see this client would not, absolutely would not agree to execute a new power of attorney saying that they were organized under the laws of the state of Colorado. They were determined that this one that said that they were organized under the laws of the United States of America was valid and good. And Glasser agreed. So we were at a total dead end, complete and total dead end. Couldn't do a thing unless this attorney agreed to hand the file off. And he did, and it closed. You know,
Egos are interesting.
anyway. Well, look what I did.
Yeah.
I'm special.
You can't.
I'm so special.
You are so special. Okay, what would you like it to do? You're at the end of you're at the end.
I'm at the end.
What would you like? You would like to what? What would you like to look at? We've got grave markers.
We don't have to, I mean, we've discussed lists of heirs and
We've
death
got-
certificates and obituaries and all of that.
I can open everything for what?
Just the slideshow,
That's what you were on, just on.
or was it?
Yeah.
Well, I wasn't getting to where I wanted to be.
Okay.
I don't know if I'm going to get to where I want to be.
Okay, there, buddy. Okay, here we go. That's the very beginning.
And this is the one that has not all the documents.
Yeah,
Okay.
the documents don't want to,
Yeah, they just don't want
they don't want to come through. Click. Bless America.
Yeah, okay.
Okay. They just don't want to come through. Just,
Okay. It's fine. It's fine.
it's fine.
Okay. This is the final list of heirs for Clarence Herring. There were 13.
13.
So, questions, anyone?
Questions? Question?
Wait, there was like someone named Jamal on the final list of heirs, so like it had his address, but
Yeah, but he wasn't there.
He wasn't there.
Oh, okay.
Yeah. Like he wasn't answering.
No, it wasn't even that he wasn't answering. He wasn't there.
Yeah.
They could
mean,
not find him.
we might be able to find him now. I mean, he could have been in prison for all we know.
Yeah.
I mean, now with I mean, this was, well, when was that? When did that happen? But yeah, we couldn't find him anywhere. In Indianapolis, right? Now we have, we have the technology. They gave it to us for free.
Yeah.
I'm now a danger to the public. Let's see. There he is. On Candy Apple Lane. Literally.
And again,
Now I found him.
and
Because this was in
he may or may not,
2019.
he may or may not be there.
May not be there.
There's a guy on Instagram from Indianapolis named Jamal Bolds Sir.
Senior,
Yeah.
SR.
Yeah. That's so odd. I wonder if that's him.
I don't know.
How many Jamal Bolts do you suppose there are?
There's just the one, but he's got a new address. And he's got a phone number.
And he's related how?
He's an heir.
He's an heir of an heir of an heir.
An heir of an heir of an heir. Yeah.
It
You
is,
probably call this guy and be like, sir, back in 2020, I
Yeah.
couldn't close on this house because you wouldn't answer the
Mhm.
phone.
Yeah. And now you're on Instagram, just posting
Just
football
living
stuff,
life.
you know,
This is the
going out to nice dinners.
Somebody else had a question the other day, which doesn't necessarily have to do with the list of heirs. It has to do with water, a water bill
a water bill
in Chesapeake
in Chesapeake.
when it came to clearing title. I think the water was included.
Stormwater is included.
No,
Okay.
in the HOA.
Oh, yeah.
And so, but they were asking this for whatever reason, and it wasn't our normal attorney's office that was doing this, but their processor was asking them, requiring the meter read for the closing.
Okay, so
Mm.
water bills in Chesapeake are not addressed because they are not liens on the property at the time of closing. So this would be something like, if you had like an oil tank, you would need to measure how much oil and prorate it so that each side paid their portion. But that would be up to the HOA.
It was so weird. I'd never had that happen.
Yeah, I've seen it before, and the HOA actually does provide the proration because they have the water
But
bills.
title has never asked.
No, because it's not a lien.
Yeah, this title girl was asking.
Well, she must have been told something by someone
Yeah.
because it's not a lien on the property. And Norfolk is the only one that the water bill is a lien on title
Yeah.
in this area. So
Yeah.
there are other areas in Northern Virginia where the water bill is a lien on title immediately, but not here. So, and so it doesn't get prorated on the settlement statement, but it should when the HOA sends in its disclosure,
Yeah.
because they know how much, the settlement date. I mean, you have to get the information
Yeah.
anyway for the dues and so on, so that that would be included.
Yeah. What
as a
was
separate
it?
line item. Okay,
It was weird.
so
It was weird. The whole weird thing. And then also, can we, just for funsies, since we have, God, please leave me alone. Can we, just for funsies, go over like the liens that survive foreclosure? Since we have a little extra time.
the liens that survive foreclosure.
Just for funsies. Like, or let's say the liens that survive death.
All liens
Survive
survive
death.
death. Yeah,
All liens survive death?
they do. They do. So, okay, liens that survive foreclosure.
Oh, wait, so all liens survive death? All of them.
Yeah. Yeah, absolutely. They all survive death.
Interesting.
Mhm. Judgment liens expire in 20 years unless the property is conveyed by a bona fide deed of bargain and sale for consideration. And then it expires after the 5th year that the new owner has the property. So there's that.
Mhm.
So yeah, Now, inferior liens don't survive foreclosure. If the lien goes on the property after the recording of the deed of trust that's being foreclosed on, then the inferior lien is wiped out by the foreclosure. Now, HOA liens are a little bit different. You have an HOA lien, which is filed against the property, not the owner, but the property. Smart lawyers file a judgment lien as well, which is against the owner of the property. And that becomes a super lien, and it has to be paid off before the property can be.
I've seen, what have I seen lately? I've seen a lot of Medicare liens.
I have never seen a Medicare lien.
That's what we've seen popping up.
Isn't that interesting?
We're seeing Medicare liens are the new thing.
Federal liens, like IRS liens and US Marshal Services liens for taking property, become super liens. They are super liens and have to be paid off.
So the Medicare liens are all gonna have to be paid off at closing?
It may be. It depends on how they wrote that law.
Yeah, yeah, especially in North Carolina, I've seen a lot of Medicare liens.
I have not seen a single Medicare lien.
Yeah. That is what we are seeing an influx of is Medicare liens.
Okay, well, back to the subject of this presentation.
Sorry.
We
It's always fun.
I wanted to discuss, what is a source deed? Okay, so the source deed is who owns the property according to the land records and whatnot. Okay, that's great. But there are exceptions to that. The exceptions are if it's a quitclaim deed, it might be a source deed, but it probably isn't because of the lack of warranty in the deed. So your general warranty deeds are a warranty of title all the way back to here in Virginia, England. Okay, so the grants that the King and Queen of England made, and you can find them. So, but quitclaim deeds have no warranty of title. So what you do is you go back to the prior deed and you get your information from the prior deed so that you bypass the quitclaim deed. Quitclaim deeds are not considered to be valid conveyances. Well, they're valid, but they're not valid. They're the worst form of deed that you can use.
What's a special warranty deed?
Special warranty deed is generally a deed due to foreclosure. And that, again, it does not warrant anything behind itself. So that's why insurance companies don't like to insure title to foreclosed properties because there is no warranty back to the beginning. No. And then you have the issues of errors in legal descriptions. They are rampant. People put the wrong lot number, the wrong block number, the wrong section number. If that happens, only an attorney can file an affidavit correcting the legal description. But we settlement agents can figure out whether or not there is a party in possession of the erroneously indicated property. So if that's the case, then the person whose file we're working on, the seller, let's say, has a problem because the property that he bought is not the property that
He received.
he owns. So then you have a a big problem if
Yeah.
that property is in someone else's possession, because that person that's in possession of the property, that actually owns the property,
Yeah.
is going to have to cooperate
Mhm.
in getting his property, getting this deed's recordation off of his property.
And you have to go through a whole bunch of stuff just to get that little thing fixed.
Just a couple of deeds. Yeah. Then, oh, lost my train of thought. Sorry, wait a minute. Well, that one left. Okay, moving on.
It'll come back like
It will
at the
eventually.
most random point.
She'll call on the night.
You're like, come back on the Zoom.
So settlement agents, title agents, have to do a great deal of checking, once, twice, and 3 times, to make sure that everything is absolutely correct, so that they can move forward with the closing. Some settlement agents want to impose blockages to closing due to various problems. They're not looking for a solution. They are, bless you, they are looking to just, I don't know why, they just want to make it difficult.
Yeah.
Um,
Some
They like
people
to
love
look
to do that.
important. I don't know.
I honestly don't know. You've run into them many a time where, they just will not close because there is an issue. And even if it's a minor issue, they just won't close. They won't issue title. So, I've run into it many, many times. Usually the buyer's side tends to control the closing because they've got the buyer's side. The seller's side generally goes along. However, with all the foreclosures that happened, the seller's side took control of all the closings because these were corporate, these were banks, these were mortgage companies, and they felt that they should have control of the closing. So it was really difficult to get the buyer's agents, because I was on the seller side, when they were selling the properties, to get the buyer's agent to listen and to waive some of their requirements because it was not your normal closing. And so I had to say no a lot. No, you're not going to charge my seller this. You're not going to charge my seller that. They're not going to pay it.
Yeah.
And on we went. So they just, kept throwing roadblocks in my way, and I just kept mowing them down.
Yeah.
And that's all you can do. And, make sure you have a good settlement agent, a really good settlement agent. Who?
We used to employ them.
They're an attorney's office. They're not a settlement agent.
But they have really good settlement agents
Mhm.
in there.
Mhm.
I really like Taylor, the new girl. She's been on it.
If someone passes away, does the property go to probate? Or it's here, then is that clear,
Yeah.
the title, probate?
Well, it is a probate division.
Yeah.
It's not a court, but it's a division of the circuit court. And what you do, you take your death certificate, you have to have an original death certificate, and you take it down there with your identification, and you file the list of heirs. It's not a normal probate proceeding. It's simply a filing,
Is that clear the title for you?
unless there's a mistake.
So my mom died, we had probate, we couldn't do nothing for 6 months, and then, so nobody showed up, and then he said, okay, here's your clean title.
Well, that's interesting, but no, that's not the way it works here. However,
They listed in like a state log, whatever.
when someone dies, there is an estate created, so-and-so's estate. And the estate has to file an accounting within a year of the death of the person. So,
If there's not a will, it's gonna take longer.
yeah, of course it is.
So if you have a will and the will has directive, and you take the will down to the probate and you give them that has everything in it.
Well, and if there's a lot of money or property involved, it takes much longer to be able to close the estate. And you really don't want to buy a property with an open estate like that because you have to do a financial reconciliation of the estate's assets and liabilities and present it to the Commissioner of Accounts. And then the Commissioner of Accounts reviews it and he puts his stamp of approval on it or not. And that is usually the end of that. But then, you have the people that file lawsuits and they say, well, I want more money, or I want this property rather than that property. I think I should have gotten this rather than that. And that will delay things.
Hearing, you know.
It's on that special list at the end of the will.
Yeah.
Yes. Anyway,
Huh?
Anything else wants from Disney?
Yeah, I mean, they fight over
they do.
fight over
They do.
really weird things.
They
So,
fight over a lot of things.
So-
And
this happened to a client of
they
mine.
fight over the dog and the cat.
This genuine, I don't know if anyone online can actually hear me. This actually happened to a client of mine. I believe it was his mother married as an adult. He was an adult. This other gentleman, who is also a realtor, was an adult, and his mother and their mother and father married each other and bought a house. And they had a will and everything, and it was to be all their assets were to be split down the center between the two boys. Both boys were adults when these people got married. And that realtor overcharged on the commission through the nose, like 15 to 12 or like 12% commission to make up the difference on what he felt was owed to him by his father versus his mother. And they ended up in court.
No, I actually saw a court case over a dog.
Yeah.
Two people wanted the family dog.
Yeah, I'd fight over the dog, the family dog.
Yeah, stranger things have happened.
That's why I only had one child. There's nothing to fight over.
Yeah, probably. I mean, I watched it with my husband's father passed, and
Yeah, I watched it when
my
my
husband wasn't fighting over anything, but like his sister wanted to fight his widow, and like they're just over. And then the estranged mother entered the chat. They haven't been married in like over 20 years, and is like, I want that roll top desk. I'm entitled to that roll top desk. Ma'am, you haven't been married to that man in 25 years. You're not entitled to anything. Stop telling your children what you want. I need you to go sit in a corner.
always best to have a will with that little
He
piece of
did
paper on the back that specifies who gets
It did
little
not
personal
specify
properties.
those things.
Yes.
He thought that his wife was going to do all the right things, and she just
Was actually a woman that I knew who put little sticky notes on all of her furniture and
Mhm.
furnishings to specify who it went to.
yeah.
And heaven only knows how that ended up
I mean,
because
because you can move a sticky note.
absolutely,
Yeah.
absolutely. So, yeah.
Take pictures, make a catalog.
Back in the day when my grandmother died, my aunts waited until my parents were out of the house and came in and rummaged through her belongings and took whatever they wanted. So,
People get weird when someone dies.
They really
I
do.
mean, they get so weird.
they really do.
They get a little crazy.
Yeah, in fact, my brother Richard, I had forgotten about that, but my brother Richard went to my grandmother's house and cleared her out
Yeah,
for the most part. Yeah, it just happens that way.
yeah, it surely does.
Mhm. Mhm.
Surely does. Anyways, all right. Well, that was fun. We've made time.
Yeah, I took a lot from it. It was
I
cool.
quit.
I'm glad I came.
Okay. I'm glad you came to.
I hope everyone had fun. Does anyone online have any questions while you have her? You can ask her anything. It doesn't have to be about this. I don't think they like you today.
Yeah.
Thank you
I
very
do not
much.
have any questions, but thank you.
Thank you.
Welcome.